More than a few times, I have spoken about the issue of sentencing on this channel in the UK, criminal justice sentencing. And that's tended to be quite generic. So for this video, I want to focus on a specific area, which is reckless driving. I've come across a case which I think really highlights this problem and the problem of sentencing. So I'm just going to read out the case. That'll be the most practical way to go forward on this video. And I want to address how the Sentencing Council of England and Wales looks at this. They're the people responsible for sentencing guidelines. Okay, this report is from this is from the BBC. It's from the 4th of October. Um, but it's for some reason it's been reported in the Daily Mail just last week. I think that's citing a case as they were um, talking about the subject more broadly. So anyway, this is from October. It doesn't cite the reporter. A driver had cocaine and alcohol in the system when he struck and killed a 6-year-old girl as she walked on a pavement with her dad in Staffordshire. John Owen lost control of his car when driving at speed before he hit Charlotte Naglis, the court heard. He pleaded guilty to death by dangerous driving at an earlier court hearing. He was jailed for 6 years and 2 months at Stoke-on-Trent Crown Court and banned from driving for 8 years for the June 2021 incident. Owen, 46, of the Square, Oakamore, had been driving his blue Skoda Fabia along Enden Road in Norton after drinking a neek earlier that day, the court heard. He lost control of his car while approaching a corner at speed, crossed onto the other side of the road and mounted the curb. His car then hit Charlotte, who'd been walking home with her father. She died at the scene. Absolutely horrendous thing for the father to go through. Owen was also injured in the incident after being ejected from his vehicle because he was not wearing a seatbelt. He was later found to have had 146 micrograms of alcohol in his blood, against a legal limit of 80 micrograms. That's almost double. Tests also found he had twice the specified limit of cocaine in his system, Class A illegal drug. Owen was estimated to have been travelling at 48 miles per hour in the 200 metres before the collision. This was apparently a 30-mile-per-hour zone. The court also heard he had been on a phone call in the moments prior to the accident, and that this could have affected his ability to drive despite it being a hand-free call using the car's Bluetooth audio system and not being a specific offence. PC Gavin Knott from the Staffordshire and West Midlands Serious Collision Investigation Unit said the sentence could in no way make up for Charlotte's death. The fatal four are amongst the most common reasons why a death occurs on the road and includes drink and drug driving, speeding and using a mobile phone while driving and not wearing a seatbelt. Sadly, all four are factors in this collision, and three no doubt contributed in the tragic death of Charlotte. This collision was entirely avoidable and has robbed the family of a happy and loving daughter. Charlotte's family said in a statement, Charlotte was so beautiful, full of life, always smiling, sassy, so brave and happy. Charlotte just started her classes, which she loved and was shining so bright in. She was loved by everyone that met her, so caring and loving. Every night since she was born, she would never sleep without holding her mum's hand. There will never be another child like her, for anyone who met her. She was taken so early from us and will never be forgotten. And in the Daily Mail report, this is from the BBC, it's just a bit more detailed, that's why I read it out. But in the Daily Mail report, it cites that the family was very angry about the sentence, understandably so. 6 years this guy got for killing a little girl. 6 years. Banned for 8 years. Now, firstly, I think he should be banned for life. I think if you take someone's life in reckless driving, you should never be allowed behind a wheel again, ever. I don't know why the hell it's just 8 years. Maybe it's some sort of, oh, well, we should give him time to rehabilitate. No, you take a life in reckless driving, you should never be behind a wheel again, ever, ever. Now, as for the custodial sentence, 6 years, that's basically the age of the victim. So he gets a year for each year of her life, but no, I'm not saying it was measured that way, but I think that's ridiculously lenient. Now, he didn't kill her in the sense that it wasn't a murder. I acknowledge that, but This guy was drink driving, drug driving. Um, I mean, that is basically like playing with a grenade. Um, so I do think it's far too lenient. I think a more appropriate sentence would be maybe 12 years in prison. I wouldn't give him a life sentence because he didn't go into her house and murder her, but 12 years in prison and banned for life from driving. And apparently, this guy has previous offences. Now, I'm going to look at the Sentencing Council and their guideline for drink driving. They're strict. This is directly from the Sentencing Council's website. There's strict alcohol limits for drivers in the UK. In England, Wales, and Northern Ireland, the alcohol limit for drivers is 35 micrograms of alcohol per 100 millilitres of breath, 80 milligrams of alcohol in 100 millilitres of blood, 107 milligrams of alcohol per 100 millilitres of urine. What happens if a person is caught drink driving? The police have the right to ask anyone who is driving, attempting to drive, or in charge of a vehicle who they suspect has been drinking to take a breath test. Anyone who refuses to supply a breath test, a breath sample, without reasonable excuse will be arrested. I don't know what would constitute a reasonable excuse. If a person fails the breath test, they will be taken to a police station for a second breath test. If that returns a positive result, that person will be charged with driving. Failure to take the roadside test or police station test without reasonable excuse is also an offence. Anyone caught over the speed limit in their car, even if they are not actually driving it, could be charged under excess alcohol in charge. Sentencing. Parliament sets a maximum and sometimes minimum sentence penalty for any offence, and they have said this on every offence category. When deciding the appropriate sentence, the court must follow any relevant sentencing guidelines, which is this organisation, unless it is not in the interest of justice to do so. Now, I want to come back to this point briefly. I want to touch on this because when I've contacted the Ministry of Justice on the issue of sentencing, they tend to pass the buck. They tend to say, well, we can't get involved in the judicial process. There's a long-standing principle of that being independent. I take that to mean they can't interfere in individual cases. But I think there's a huge problem here with passing the buck. This is the Sentencing Council saying that it's Parliament that sets the actual sentencing, rather than just it being legislation, i.e., it's illegal to do this, that they pass the sentencing, the upper limit. So I think this is a case of who the hell is responsible. I mean, supposedly we have a situation where legislators set the law, the Sentencing Council of England and Wales sets the guidelines, and judges work on those guidelines, but all three components, Parliament, the Sentencing Council, and judges, the judiciary, they will all say, "Oh, my hands are tied," because so the legislators, politicians, will say, "We cannot. This is an independent decision. We can't interfere with the judiciary." But they're the ones who set the law, who make the law, and according to the Sentencing Council, set the maximum and minimum terms. I thought that was the Sentencing Council. So it's just this constant pass the parcel on sentencing, as far as I'm concerned. But I think the guidelines, it's the Sentencing Council that does that. So I think they are largely to blame when we see soft sentencing. What is the penalty for drink driving? If a person is found guilty of drink driving, they could be banned from driving, fined, or even sent to prison. The sentence depends on the severity of the offence and it's decided by a magistrate's court. In this case, it was Stoke-on-Trent. The maximum sentence for excess alcohol attempted drive is an unlimited fine and or 6 month custody. If the offence was attempted drive, the driver will also lose their licence for at least 12 months. The court may offer a reduced ban if the driver completes a drink drive rehabilitation scheme DDRS course. These two examples are both in cases where there hasn't been a death. If the offence was excess alcohol in charge, the maximum sentence is a fine of up to £2,500 and or 3 months custody. The offender may lose their license or receive 10 points. How is the sentence worked out? Aggravating factors may increase the severity of the sentence. Examples include previous convictions relating to the nature of the offence, if the driver was carrying passengers, evidence of an unacceptable standard of driving, if the driver was involved in an accident, that applies in this case, if there was a high level of traffic or pedestrians in the vicinity. Now let's look at those aggravating factors. This defendant had previous convictions. Um, there was obviously an accident involved, a little girl died. Um, so those are already aggravating factors. Mitigating factors may reduce the severity of the sentence. Examples include no previous convictions or relevant recent convictions. If it was a genuine emergency, that I assume is if you're drinking with friends in a pub and then suddenly you get news a relative's in hospital and you have to get to them. If the driver's drink had been spiked, that's obvious that it wouldn't be their fault. If the distance driven was very short, well, Leek is a town. This accident, I believe, occurred in Stoke-on-Trent itself. There's a bit of a distance there. If the driver showed remorse or was of good character, the report doesn't state if he showed remorse, but he did admit his crime. If the driver has a serious medical condition, mental disorder, or learning disability, doesn't mention that in the case if he had that. If the driver is the sole or primary carer for dependent relatives. If the defendant pleads guilty, they will also receive a reduced sentence, although not a reduced disqualification period. I'm not convinced that should be a reduced sentence at all. Pleading guilty. I suppose it's to spare the victims the trial. I suppose that's the logic behind it. But to me, 6 years custody for taking the life of a little girl, or taking the life of anyone, is too lenient. Now, I recognize it's not the same as, premeditated murder, going and killing someone. It's not the same as that. I recognize that. I mean, he didn't intend to kill a little girl, but his recklessness with the fact that he was drink driving, using drugs, anyone with any ounce of common sense would know that is a dangerous thing to do. So I think there needs to be a deterrent, a much tougher deterrent with cases like this. The thing that really, really grains on me is not actually the custodial part, although I think 6 years is too soft. It's the fact that he can actually legally be allowed to drive again after 8 years. I think that's perverse. I think if you kill or seriously injure someone, you should never be allowed to drive again, ever. Why the hell do they say, oh, well, 8 years and you could drive again? So he'll serve his 6 years in prison. He might get out early for good behavior. Then, after 8 years, what is that? That's 2030. He can drive again. Now, if he hasn't been rehabilitated, same thing could happen all over again. It's outrageous. I think if you have killed someone or seriously injured someone, then your hands should be barred forever, forever, from drink driving, from getting behind a wheel. And I think even if you haven't killed or injured someone, it should be a very, very lengthy ban. You know, 8 years for life, it's not enough. Really, really not. 6 years custody for taking life is not enough. Again, I'm not saying it's the same as murder, but this guy had previous offences. I can understand why the family was angry. And this is one area. The other I would cite is youth crime, young offenders, where there just isn't an effective deterrent. Um, I think if people who were cavalier with drink driving and drug driving knew that they would never be allowed to drive again, ever, then maybe they wouldn't do it. And maybe I'm being naive, maybe they would. But a lifetime ban, definitely is more appropriate if you take someone's life or seriously injure them. The sentencing council, their logic is just soft. I mean, the family will understandably be seeing this as, well, the court sees our daughter's life is worth just 6 years. Now, I don't think you should get a life sentence because it isn't the same as murder, and then you'd have a situation of, well, a child killer, like someone who actually kidnaps and kills a child, would have the same sentence if it's a life. So, which would have to they'd have to have a harsher sentence. So that would be a problem. But I think 12 years is probably about right, i.e., the sort of sentence that you would get for second degree murder. Um, Something equivalent to that. I just think 6 years is too soft. And I've heard of even more extreme examples. There was an offender who killed four people in Leeds, and he went to prison, Young Offenders Institute, served a bit of time, came out, and was involved in another accident because the Eustace judge had given such a soft sentence. Um, I just think generally the approach in this country to reckless driving is far, far too lenient. I think drink driving and drug driving should be seen as extremely serious offences. Now, if someone is going, let's say, 40 miles per hour in a 30 mile per hour zone, but they have no drugs or drink, that can be a fine. I don't think that's in the same category. But to me, basically, if you're drink driving significantly or drug driving, I mean, this guy had everything. He was talking on the phone. I don't care if it was hand free. The point is, he's distracted. I mean, it's outrageous. So I hope the family is successful. They have a Facebook page. I'll put a link to this. I'm sure they won't mind because they'll want as much publicity as possible. Please sign up to it, give them support. What they're trying to do is get this referred to the Court of Appeal to get a tougher sentence because of the nature of this, because the little girl is gone. I really do think it should be a tougher sentence. I'm not saying, like I say, it should be the same as murder, but it should be tougher. I think 12 years is probably about right, i.e., double what he actually got. Um, and he should be banned from life. 12 years in prison, banned for life from driving would be more appropriate. 6 years in prison and 8 years driving ban. That's, I don't think that is reflecting the gravity of taking a little girl's life. I just don't. So this has to change. Um, Sentencing council needs to start listening. They're tone deaf. I mean, they have consultations, but I'd done a consultation recently, and it was entirely about the wording of legislation. It wasn't about sentencing itself. So I'd done it, but it took an hour. It was comprehensive. There were a lot of questions about, like, do you agree with the wording? Do you agree with the wording? But none of it was actually about sentencing itself. They said this is purely about the wording and not affecting the actual sentencing guidelines that we determine. So what's the point? I done it because I don't want to just say I'm not doing anything, but I just find it hard to respect this organization because I think they're tone deaf. And the two big areas I would change is when it comes to this sort of driving offences and particularly youth crime. When you have a gang of feral teenagers harassing someone in their own home and they get a tap on the wrist, no, they should be going to Young Offenders Institute. I believe we need to get much, much tougher with teenage offenders. As it stands, and the sentencing council is largely to blame for this. It's a softly, softly attitude. Oh well, we want to see if they can rehabilitate. But when you have a 16-year-old who has notched up dozens of offences and they're literally laughing at the justice system, the clear message is it needs to get tougher because they're not taking it seriously.